An explosive allegation sheds new light on why a mistrial was declared in a high-profile sex trafficking case in Erie County.
The district attorney's office dropped a bombshell in the lap of the judge just as the trial was winding down. News 4's Luke Moretti is here with the story you're seeing only on 4. Luke?
Jackie and Don, News 4 Investigates has been digging deeper, obtaining court documents and transcripts that paint a more complete picture of what led up to the judge's decision.
Every single citizen should be concerned because this is not the way the system's supposed to work.
Criminal defense attorney Mark Satcha is not mincing words these days.
They pulled a stunt. He should have denied it, and we should have gone forward.
Satcha is talking about the sex trafficking and drug trial of Miguel Perea that recently ended in a mistrial.
It's a violation of due process. It's a denial to my client of constitutional right to a fair trial.
The judge in the case, James McLeod, declared a mistrial, a legal move that prosecutors had requested. At the center of this, a sworn statement given by one of the government witnesses in the case. She claims that Perea told her a few years ago that he sold drugs to Judge McLeod on several occasions.
It was based upon a very unbelievable person who was actively using drugs and was denied by my client and denied by the judge, and the judge should not have declared a mistrial.
Judge McLeod said in court the allegations were false and without merit. The timing of the mistrial happened as prosecutors were winding down their case about 2 weeks into the trial.
What we really have is a 2-page affidavit that hasn't been tested by cross-examination, that hasn't been tested at any type of hearing.
Defense attorney Michael Taheri, who has no connection to the case, believes McLeod used his best judgment given the circumstances.
I think the judge may felt it has contaminated him in his ability to be objective and fair. So the defense is entitled to a fair trial, not a perfect trial.
The bombshell allegation prompted a spirited back and forth in the judge's chambers between prosecutors and defense counsel. Mark Satcha asks, why is it that we are taking this affidavit in any way accurate, according to a transcript obtained by News 4? Satcha continues, this creates a problem for my client. It creates prejudice for my client.
I said, what? This is probably all untrue, according to my clients, totally untrue. Shouldn't we know the truth of what these allegations suggest?
While still in chambers, Judge McLeod agrees that Satcha should be given an opportunity to question the witness before deciding on whether to grant a mistrial. I would like to have as much information made available to me before I make that decision, McLeod tells lawyers on both sides. What Mr. Satcha comes up with, if anything, may have absolutely no impact on what I do.
We've got a person who says that the defendant did this, the defendant denies it, the judge denies it. And I think the only way we're going to learn more is at a opportunity, when there's an opportunity for the defense lawyer to question that person who made the claim under oath in an open courtroom.
But Satcha never got the chance to question the witness before McLeod declared a mistrial, something Satcha vehemently opposed.
I feel sorry for the judge in that the way that this came up was disgraceful, and I respect him. But I totally disagree with him about his decision to declare this mistrial.
The district attorney's office sent a letter to Judge McLeod regarding the witness allegation. Prosecutors argued that neither the defendant nor the people can be afforded a fair trial, whether true or false.
That suggestion was that if, in fact, someone comes up with a false accusation against the judge at the end of a trial, so either party can do this now and get out of a bad result. I mean, in a way, it's funny, but in a way, it's astonishing.
Miguel Perea now faces a retrial before a different judge. Satcha tells News 4 that he's exploring what, if any, recourse is available.
In my mind, this was this was not well-intentioned. This was a decision that was a misjudgment at the least, and it amounted to judicial blackmail
on the part of
the DAs that were directly involved in this case.
In a letter to Judge McLeod before the mistrial ruling, Satcher writes, "Desperate prosecutors do desperate things. This mistrial motion is a last-ditch effort to avoid an acquittal." Mike Taheri says Satcher could argue that a second trial would be constitutionally unfair, citing due process concerns and the possibility of double jeopardy.
I'm sure defense counsel felt, look, I am going to win this case. I don't want this mistrial. And that may be part of his application or his motion to prevent a second trial.
Now, in the past, McLeod has admitted to struggling with drug and alcohol issues when he was a private attorney. That was decades ago. He sought treatment and turned his life around. In 1999, he was elected Buffalo City Court judge and has been serving ever since. McLeod did not return phone calls seeking comment about his decision to declare a mistrial in the Miguel Perea case. Erie County District Attorney John Flynn also declined to comment, would only say Perea will face a second trial next month. And by the way, a different judge has been assigned to that case.
So it'll be a second trial.
Retrial on it.
The whole time I'm listening, I'm thinking this is the kind of thing they study in law schools. What do you do in a case like this? So unusual.
These things come up.
Yeah.
You never know, right?
Thank you so much,
Okay.
Luke.